Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe. For today's early morning edition of Uncivil Live, we are dealing with a recent TCPA decision from the Court of Appeals in the state of Texas, related, tangentially, to the Vic Mignogna case. So we need to bring everyone up to speed on what all those things mean. All right, so first of all, what is the TCPA? Well, the TCPA is the Texas version of the anti-SLAPP statute. It's the Texas Citizen Participation Act, I think. I never quite remember the acronym, but yes, it's something along those lines. But basically, it's the First Amendment law that prevents people from suing merely to silence other people, all right? So if you're trying to suppress lawful speech, it's a special motion to dismiss. So you make some special arguments. It allows a case to be dismissed earlier if defamation is being brought in a false way. So that's the TCPA. And what is Vic Mignogna? Well, Vic Mignogna was a guy, and still is for that matter, but he was a voiceover artist, most notably for Dragon Ball Broly, the character. Perhaps he's also known for other roles that you may know him better run. And basically, long story short, he got Me Too'd. He got accused of various indiscretions by his fellow actors, and he sued for defamation, and they basically brought a TCPA argument saying that no, what you're saying is invalid, this case should not go forward. And Vic Mignogna lost, and he was assessed $500,000 worth of legal fees, because under the Texas Citizens Protection Act, you can get legal fees. Remember, I've stated how the American rule is every side pays, but that can be augmented by statute, and this would be one of those times. So we've been waiting for a little while now for a decision in the Vic Mignogna case. It's almost been 6 months, I think, on whether or not the trial court screwed up. And we had a whole series of cases related to this, talking about the judge, talking about the various parties, talking about all the things, right? And criticism of me ensued. But when we last left the action, we were predicting Vic Mignogna would lose. Vic Mignogna would lose his appeal with a 90% confidence. But there has been a new decision on the Texas Citizens Protection Act, which is from the same Court of Appeals on the same subject. So there has been perhaps a change or modification or a re-understanding of the law. And so we can read this decision and maybe tease out some leaves and see, because these cases are being written relatively contemporaneously, the Vic Mignogna case hasn't come out yet, but one would presume they're being written relatively contemporaneously. Perhaps we can tease out some thoughts in this case that might relate to Vic Mignogna and perhaps augment the odds of our prediction. So we will see what's going on and go from there. Great. So let's do that. So this is in the Court of Appeals in state court for the 2nd Appellate District of Texas at Fort Worth in the case of Miller versus Watkins. And then I always love these numbers because it just goes to show how big Texas is. This is on appeal from the 393rd District Court in Texas. I just love these numbers because it shows how big it is. How many district courts does Texas have? Yes. Okay, let's see what we got here. All right, let me, yeah. All right, so in this accelerated appeal, and TCPA is an accelerated appeal, normally it allows for earlier hearings than would be heard otherwise. Appellant Carlisle Jones Miller raises two issues, challenging the trial court's denial of the motion invoking provisions of the Texas Citizens Participation Act, the TCPA, or the Act, otherwise known as the Anti-SLAPP Act, by which she sought to dismiss the suit against her. Watkins' suit alleges cause of action for defamation and tortious interference with actual and prospective contract. Well, that sounds very familiar to Vic Mignogna. That's, I think, literally the same causes of action as memory serves. The suit alleges that Miller had made defamatory statements to various government and private individuals when she challenged whether Watkins should be permitted to teach classes at school when Miller's daughter was a principal? Well, communication to governmental actors can raise some interesting challenges on defamation, because there's an idea of being able to speak to the government, and it can be a bit problematic when you're trying to prove defamation when the nature of your communication was to the government. So the government is technically a third party, right, if you're concerning someone else. But the fact that you're talking to the government changes the analysis. We haven't really gotten into that in any of our defamation cases, but it can be a factor. The private individuals, of course, less so, depending on the context and what we mean by private individual, but I guess we'll see what's going on. Jamie said, isn't one of the judges on both the cases? That may very well be true, Jamie. I don't know. Your memory might be better than mine, which would be even more predictive, one would assume. Miller moved to dismiss Watkins' suit, claiming the statements she made were an exercise of rights protected by the TCPA. Watkins responded to the motion by filing several items of evidence she argued established a prima facie case for each essential element she had brought. Trial court found that Watkins had met her burden to establish a prima facie showing that the claims were meritorious and should not be dismissed. Okay, so this person said they were able to overcome the hurdle of TCPA, and the trial judge said, go forward. And then you have the right to appeal that as an interlocutory decision under the TCPA. Interlocutory just means in the middle of trial. So when you say you have the right to keep going in the trial, then obviously the trial keeps going. But you can appeal that decision right away in the middle of trial because the rules allow for it. We conclude that the trial court's ruling was correct. This opinion focuses on our conclusion that Watkins present prima facie proof establishing elements of defamation. Because this conclusion is dispositive, we do not address whether Miller properly invoked the TCPA. Also, we do not address whether Watkins present prima facie evidence of tortious interference, because that appellate contention was waived by Miller due to being inadequately briefed. Okay. Yeah. All right. So I'm just trying to figure out how that would impact things going forward. Yeah, if she says there's not prima facie evidence and the case is dismissed, then I suppose the trial judge could reverse their own order. But absent that, it would be dead. We also overruled Miller's contention that Watkins lacked standing to bring suit because she failed to comply with Texas Defamation Mitigation Act, and the trial court should have considered the request for injunctive release to be a discrete legal action that's subject to dismissal under TCPA. Oh yeah, so there's rules on how you're supposed to mitigate defamation, mitigate the damages in Texas. Okie doke. To set the scene for these parties' disputes, Miller and Watkins each have a daughter who attend the same elementary school, are in the same grade, and are friends. Miller and Watkins were both active in the PTO of the school that their daughters attended. Watkins was one of the parents who taught a PTO-sponsored art class called Meet the Masters, and was also qualified as a substitute teacher for the school. It's apparent from the record that Miller and Watkins have a history of conflict. So their kids might be friends, but the parents themselves maybe less so. The controversy that led to Watkins' suit against Miller was sparked by an electronic mailer that Watkins had sent her ex-husband, with whom she shared custody of her daughter. The message objected to their daughter spending time at Miller's home. The message claimed, among other things, and so it's ex-husband here, so that wouldn't deal with marital privilege, so we don't have to worry about that issue. The message claimed, among other things, there had been a number of incidents at the school involving that family that were concerning. That police report had been filed against Miller for harassment, and they presumably, meaning members of the Miller family, had disparaged the ex-husband. A little vague. The message was passed to Miller. So she said nasty things about Miller to her ex-husband, and her ex-husband or someone else passed it to Miller. So now Miller knows about it. The receipt of message produced several actions by Miller. She stated her views about Watkins on Facebook, texted and telephoned other parents who were also in contact with Watkins, and contacted the principal of the school that Watkins and Miller's daughters attended. Okay, so Miller is now going to express some of her thoughts. What Miller said is documented in the record, which includes copies of the text and Facebook posts and copies of her emails and other communications with the school. So we have all the things that she said in writing, so that makes things a lot easier. These documents became part of the record because other parents who texted with Miller or her friends attached copies of the text and posted declarations in support of the TCPA. So these messages got spread around in the gossip chain. A business records affidavit from school district's custodian of records attached the communications that Miller had with the principal of the elementary school and also with other school district officials. That would be the governmental action part of this equation. The attachment to the business records affidavit told 229 pages and spanned communications over a 4-month period. So we have a lot of things that people said. Further, other parents outlined in their declarations what Miller had allegedly said during telephone conversations, which isn't in writing, but at least it's prima facie evidence, right? So in the absence of something that would completely contradict them or show them to be completely unreliable, we can rely on their statements as prima facie evidence. It's just on its surface evidence. Doesn't mean it's true, obviously, but it does suggest that there's some evidence that's beyond mere speculation. So I think we can say a sworn declaration or sworn affidavit is beyond mere speculation. So it's prima facie. Below, we outline the statements that Miller allegedly made about Watkins. To give some context of these statements, we note Watkins concedes that certain statements made about her past are true. Great, then it's not defamation. That makes that easy. Watkins acknowledged that she'd been arrested for public intoxication 10 years prior. Miller, 10-year-old public intoxication seems like a weird thing to bring up about your parents, your friends' kids. 10 years ago, they arrested for public intoxication. Okay. Miller also obtained and provided to the school a 10-year-old record of Child Protective Services family team plan, which apparently was at least partially prompted by this public intoxication arrest. Someone called CPS and required supervised visitation for a period of time when Watkins visited with their children. CPS sometimes, man. I hope there's more to the story than they're telling me, because that sounds kind of dick. Miller asserts that her impetus for communicating with the school principal about Watkins, excuse me one second, and we're back, was because Watkins actually substitutes for the school and helps with the art program, and because Miller felt like this finally needs to be addressed. During her communications with the school, again, this will be the governmental part of the equation, Miller made a host of statements about Watkins. These include the following. Though Miller did not think that Watkins would harm Miller's daughter felt unsafe around Watkins. Okay. Which, since they're friends, probably maybe not. Oh, yeah, but it's the adult, so maybe. Miller stated, if she was just a crazy parent slandering my name, I wouldn't be talking to you guys right now, but she's employed at the school and she's been around my children. I don't feel safe like we've been around for all these years. So she's an employee at the school. So that might get into her being a governmental actor in some respects. So this is important because you can't defame the government. This is the lesser known holding of New York Times versus Sullivan. It is not possible to defame the government. So it is possible to defame individuals who work for the government, but not the government. So that raises the potential question of, when we're making statements about this person who works for the school, at least raises the specter that we might be talking about the government, because depending on exactly what we're saying, we could be talking about how the government conducts its hiring practices or something like that, right? So if we're talking about the government, the defamation is completely off the table. So that's the lesser known holding of New York Times versus Sullivan. So just an item of note. Miller stated if she was a crazy parent, she wouldn't worry about, but she works for the school. Miller claimed all you have to do is talk to enough people to know there's something psychologically wrong with Watkins. But Miller would not provide names because she did not want others to be dragged into controversy. Watkins had CPS charges including child endangerment and public intoxication, which apparently seems to be true. And Miller obtained copies of records to ensure Watkins was no longer allowed on campus. Watkins had been to a mental health hospital and was institutionalized. That's a factual claim, which we haven't yet seen evidence for. Miller obtained public records to show Watkins should not be at school. If they're public records, then that seems okay. Watkins is adult bullying at its finest. That seems like opinion. Miller pretended to contact CPS to communicate about the email that Watkins had written to her ex-husband. Miller planned to contact. I don't even know what that means. The police told Watkins to stop following Miller. That's presumably a statement of fact. According to Miller, the psychological abuse on Miller's kids by Watkins is sickening. The idea that there is psychological abuse, that's not just opinion. Like, sickening is an opinion. Psychological abuse is fact. Miller had proof that Watkins had been stalking her on social media, allegedly confirming conversation with Watkins' son. Stalking, even if we're using it in a more informal sense. So if we're not using the legal definition of stalking, which incidentally, people misuse the term stalking all the time. It seems to me that most of the time people use the term stalking, it's not stalking. So people have sort of a colloquial understanding of stalking, and there's a legal definition. So we could query whether she meant the legal definition or a colloquial definition. But either way, that suggests actions that could be proven or disproven, right? Miller knew of no instances in which Watkins' misconduct had occurred at the school, but Watkins volunteered at the school, and Watkins' efforts to slander Miller had to stop. Miller stated that she talked to the local police department, and they were going to set up a meeting with her for an investigator, but they said Miller should go ahead and talk to the school and see they're going to do something. That the police communicated this to her, I guess, could be a statement of fact. Miller reported that she had just finished with the investigator. He will be contacting Watkins. Stop harassing me and saying things that aren't true and searching my social media. The investigator is also going to contact I believe this is the school district's police, to let them know what's going on, because even though they hadn't done anything at the school that we know of, other than negatively affect the friendship, they need to be aware that's told to stop. That suggests a whole bunch of facts, that the police said these things, that they were planning on taking these actions. Could be rebutted by a police statement. Miller's daughter was excused from activities because of her actions of an evil mother. That's bullying. I think that's more opinion. Evil is an opinion. Bullying, probably an opinion. Maybe it's factual. I don't know. But it strikes me more as opinion. Sometimes the boundaries between opinion and fact are not super clear. But I'll give you my initial read on it. So bullying, maybe more of an opinion. Watkins' child is afraid. And if it is a statement of fact, it's a pretty light one, it seems like. So if you say that bullying is a statement of fact because it can be proven or disproven, the things that could theoretically qualify as bullying is a pretty long list. So if it's a statement of fact, it's a very loose statement of fact, I would think. What is bullying is a little bit in the eye of the beholder. Watkins' child is afraid of her mother. Watkins punishes her daughter for associating with Miller's daughter, and this is sick behavior. That she is afraid is a statement of fact. That sick behavior suggests opinion. The situation has got out of hand and goes beyond the harassment we've been dealing with for years. A patient involved in the school is forcing her child to exclude her best friend, all for her own evil agenda. Evil is opinion. Forcing her child is fact. Watkins had a public intoxication on her record, and Miller forbade Watkins to be anywhere near her daughter. Both statements of fact, although the intoxication seems to be true. Miller asked the school to keep Watkins away from Miller's daughter anytime Watkins was volunteering. Statement of fact, either she did or did not do that. Miller stated that she had to involve CPS now because Watkins should not be around my child ever. There's no reason that children should be hiding, scared at school they attend because of a horrible volunteer mother. That she involved CPS is a fact. The rest seems kind of opinion-esque. This is a good exercise to try to figure out what is opinion and what is fact. So the reason I'm spending some time on this is just to spend the time of the exercise trying to, at least for myself, determine in the first instance what I think is opinion and what is fact. I mean, obviously it doesn't really matter for the long-term conclusion, or I can't imagine that it's going to matter, right? Because the question is whether or not there's enough prima facie evidence of defamation. So if even one of these statements is potentially factual and there's evidence to support that, it's knowingly false and all the rest of it, then it doesn't matter how many of them are. So going through this is more of an exercise for me than really for the case. So trying to figure out like which of them are opinion, which are facts, is just helpful to keep one mind sharp, and also try to see where people might disagree with me. Watkins is bullying my family and her own daughter. Either opinion or very loose fact. What you guys did by excluding my child instead of removing the bullying is disturbing. Excluding my child, potentially fact, but potentially a loose one. Found out she was not able to give Watkins child endangerment records or records of her being, she's not able to get the records, but her ex-husband was in the process of doing so because she's causing so many problems. Yeah, that's probably factual. Watkins has to stay away from the school until my child is gone. I'm not sure what that is. That just seems declarative. I'm not sure that's opinion or fact. It's just like a wish. Miller stated that she had to contact her police department again. That she contacted again would be fact. And their process of getting emailed together, fact, stating that Watkins is slandering my name by saying, I have charges against me. I have charges against me is a fact. Not only is she hurting my child, she's also hurting her own child. Opinion. And making it hell for me when it comes to volunteering at my school. Opinion. This is all illegal. Conclusory. And you guys aren't taking it seriously. Opinion. Miller provided notes from the local police department where she described the interaction both Miller and Watkins had with the police. The notes also stated, I am duest number 406 met with Carly Miller, a white female of Krugerville, Texas. She spoke with Officer Bray, number 416, on 10/24/19 regarding a potential harassment issue between her and Michelle Watkins, a teacher at Brockett School involving both teachers. I advised her the best way to quash this issue was to deactivate her Facebook page, as Watkins was likely using her friends of friends to backdoor into her page. Miller had also spoken with the principal at Brockett, and the principal agreed to keep Watkins away from Miller's daughter while she is at school. She did not allow Watkins to teach her daughter's class. Miller stated that she had a common element in the harassment, her biological father of Watkins' daughter and her ex-husband of Michelle Watkins. So the biological father of Watkins' daughter, oh yeah, okay, that makes sense. In the conclusion, Miller was advised that posts on social media are viewed as an extension of the First Amendment right of freedom of speech. Yeah, in principle, or in broad, yes. That you express it online doesn't change the First Amendment analysis particularly. And then a criminal offense may not be applicable. That's quite possibly true. Even if it's slander, even if it's libel, even if it's defamation, it does not necessarily make it criminal. However, I also advised her that Michelle Watkins would be advised to cease her stalking of Miller online and through social media. I contacted Arbery ISD Police Department Chief Collins to advise Watkins of the issue and notify her of the person to refrain from stalking, harassing, or impersonating Miller. Well, that seems to validate a lot of the things that were said, and she communicated a lot of these things to the police. So that seems to back up the story, assuming that these are correct transcripts. Officer Bray, number 416, spoke with Carly Miller of Krugerville regarding an ongoing issue with Michelle Watkins of Arbery. Miller states that she believes Watkins had been creating false Facebook profiles in order to spy and send messages to other individuals to slander Miller. Miller stated that Watkins is in a group of school parents that just don't like her. I advised Miller of the law regarding online impersonation, and there could be a potential for criminal charge if Watkins had been using the information of another person to create the profiles and using them with intent. That would be the key of that sentence, to harm Miller. Miller has a scheduled meeting with the school, which both parties' children attend, and she stated that after the meeting, if nothing can be worked out with the school and Watkins, she would gather information evidence she has of Watkins using a fake profile to harm her and bring it to the PD. I advised her that slander and defamation falls within the civil code. It's not criminal. Yeah. So that seems to back up a lot of those earlier statements in terms of what was communicated to who and stuff like that. So there's some validation there. Miller emailed the school stating she had an email where Watkins was slandering Miller's name and saying the school knows about me, including emails proof from the police department what she's saying was false and flat out lies. Someone like this should not be volunteering at the school. Needs to stay away from the child like I was told. Yeah, I mean, the statements speak for themselves and they can be analyzed on their own terms. So whether or not Watkins was lying could be evaluated, at least partially, maybe, by the statements, although they're from Miller, so, Needs to take away from the school like I was told. I mean, the school can evaluate that for themselves. That's kind of an opinion, I think. And also it's a communication to a governmental actor in that situation. It's because they emailed the school. So again, when you're contacting the government, that the analysis can change. In another email to school, Miller stated, Watkins is the bully here. Why is it not enough that I have proof that she stalks my social media and proof she says I have a harassment charge against me? I have police department saying that's a lie. How can she continue to torment these 2 children at school? I don't know what that is. A volunteer at school cannot make up lies about another parent when the police department was saying that her words were not true. I don't think that's what the police department is saying, but no one can make up lies about another person. A lie would be a false statement of fact. So, yeah. Watkins will continue to harass and hurt me and my family. Opinion. It's speculative opinion if that too will continue. When Miller provided at the school a report from Child Protective Services more than 10 years before the present controversy, she characterized it as possible. This is a CPS meeting showing everyone on the first page that has firsthand knowledge of the arrest for public intoxication. It shows she only could have supervision with her own children, and she also has a drug and alcohol problem that caused intervention. Well, either the first page of that does or does not reflect that. And as I mentioned before, there is this thing called the fair report privilege, which applies particularly when it comes to government documents. So as long as you're reporting on it fairly, as long as you're characterizing it fairly, then that makes it a privileged context, right? So if that's what the document says, even if it's false in some way, the fact that it's coming from a government document is important in the analysis. It's very important in the analysis. So we get to learn a lot more. We get to learn some more things about defamation, right? So this is a CPS report, means it's coming from the government, meaning the fair report privilege might apply. So as long as you're reporting on it fairly, it might not be defamation, even if false. Miller also provided this because assuming the report says that, that's the whole key to this. Assuming the report actually says that, right? If the report doesn't say that, then fair report privilege obviously doesn't apply because it's not a fair report. Miller also provided the school with a copy of a mugshot of Watkins as documentation of her arrest. Okay, if it's a mugshot, then great. Also, that would be a government document. It's a photograph taken by the government. And a copy of what she sent with an email stating that yellow line 3 is her public intoxication arrest from 2010. This is her mugshot from jail. I'm doing this because I've been told she is taking me to court. Having all the details is important. Having all the details is important. She attacked me first. I'm only doing this because facts have to be shown. Well, if it's a fact, it's a fact, right? Even though Watkins' arrest and CPS involvement happened many years ago, she's presently hurting my family, mostly my child. For a school that has shouts of no bullying policies, I'm deeply disturbed that 2 kids have been talked to school with the same story and nothing's being done. All she does is lie. Kind of opinion. You all need to be aware that you've sided with an evil liar. So many more people are going to have to go through this unnecessary court appearance. A liar, it's either opinion or a loose fact. Yeah. Because what makes someone a liar is a little bit tenuous. Watkins, a parent of volunteer, has been stalking, harassing me. That seems factual. My child no longer feels safe at school. Factual, whether a child does or does not feel safe. Miller also provided the school with documents from the local police department that details the contacts with them. Thanks for the nice comment about the haircut. I've been getting a lot of positive comments about the haircut, and I really, really appreciate it. For Zuki, who asked, who is Vic? Vic Mignogna, we covered this at the start of the stream, but Vic Mignogna is a voiceover artist who got Me Too'd and is in an ongoing lawsuit. And so we're reading a decision that just came down that might be informative as to his lawsuit. We've done maybe 10 or 12 videos on Vic Mignogna on this channel. So we're trying to read tea leaves, man. Specifically, she provided a letter from investigators. She claimed proved that she had not filed criminal charges. Letter also indicated that she had reported potential criminal conduct. Specifically, the letter stated that as of this date, Carlisle Miller has not filed a police report against Watkins with the police department. Carlisle Miller has been in contact with officers to describe potential criminal offenses, and request insights or opinions. However, no police report or criminal charges have been filed and are not being considered. So when Carlisle Miller was saying if Carlisle Miller said she filed a police report, that might have been her understanding. It might have been true from her point of view. So the police say, well, it wasn't actually a police report. It was merely a contact to describe criminal offense. And so to expect Miller to necessarily slice that distinction, so we could give her a break on that one. Immediately after Watkins filed suit, Miller initiated an appeal process with the school district of the school that Watkins and Miller's daughters attended. Okay. The school district appeal has two bases. First, Miller claimed the school principal had lied about statements her daughter had made to the school. Okay. I'm not sure what the principal's motivation would necessarily be, but all right. Second, Miller claimed that it was not until after school officials had lied that they sought to have Watkins removed as a volunteer at the school. All right. The school district denied the appeal and observed a number of statements made by Miller that they sought to exclude Watkins from volunteering at the school predated the events she claimed were motivating for having Watkins excluded. So the school district, at least in their internal analysis for their process, which is a whole separate thing from defamation, right? It's a wholly separate issue. The school district said no, because a lot of these things predated the events that are motivating it, and which in the school district's opinion or conclusion means they're not relevant. So, okay, let's take their word for it. This is too far in the past. It doesn't matter. It's too old. Doesn't matter. Okay. All right. Fair enough. As noted above, two parents of the children attending school attending by Miller's and Watkins' daughters swore to declarations that Watkins failed to establish a prima facie case. It does look like we have, we don't know about, we're getting to the prima facie elements. Because so far we have a whole bunch of statements. We have a whole bunch of writing. So we have some stuff there. Yeah. Two parents of children attended by sworn declarations that Watkins filed to establish prima facie, while other parents itemized statements that Miller had said as follows. So here's what this other declaration from this other person witness says. Between text statements and phone calls, Carlisle Miller made the following statements about Watkins. Watkins had removed everything out of her daughter's room and forced her to sleep on the floor as a punishment. Fact. Walker's daughter didn't want to live. Fact. Watkins doesn't need to be at Brockett. Opinion. Watkins has a criminal record. Fact. It's unsafe for children to be around Watkins, including their own children. All right, let's spend a little time analyzing this one. It's unsafe for children to be around Watkins, including Watkins' own children. Okay. So, on a surface level, that looks like an opinion. But there is, of course, because everything gets endlessly complicated as we dive into the levels, right? So we've started with some superficial understandings of defamation, and now we have to go another level deeper. So an opinion can be defamation if the opinion appears to convey facts that are not generally known, or appears to rely on facts that are not generally known. So if you make something that's a pure statement of opinion, but the opinion is based on private facts, then it can be concluded that you're in some sense conveying the fact or the facts. So to say someone is unsafe around someone else is kind of an opinion. But to say that they're unsafe for children to be around Watkins, right? It seems to suggest something a little bit more factually based. It's like, what is the basis of that opinion? Now, it could be the CPS reports, which maybe is public record, so maybe we're in the clear. But it's probably a mixed statement of fact and opinion. So, yeah, it's probably not a pure statement of opinion. It's probably a mixed statement of fact and opinion. So we get to spend a little time dissecting what is and is not opinion on another level. Watkins stalked her ex-husband's house when the children were in her possession. Factual. Watkins had stalked Carlisle Miller on Facebook and created profiles of friends so she could control her. Factual. Watkins is unstable. Opinion. Watkins should not have her position at the school because she's not safe. Is not safe, again, could be a mixed fact opinion. Right? So it could read as pure opinion, or it could be read as a mixed fact opinion. It's relying on facts not generally known. Carlisle Miller is worried for the safety of Watkins' daughter because she's not stable. Opinion. The other parents stated in the declaration that between the text messages and phone calls, Carlisle Miller made the following statements. That Watkins was not fit to be at the school. Could be mixed fact opinion. Abusive to children. Factual. Abuses her own child. Factual. Is a troublemaker. Loose factual. Because what a troublemaker is kind of loose. So it's either opinion or loose factual. Dangerous. Could be mixed statement of fact and opinion. Why is it dangerous? What is the nature of that opinion? Should be removed as a teacher from Meet the Masters. Well, that's just pure opinion. Saying someone should be removed as a teacher is just a pure opinion. Watkins had stayed stalked Miller on Facebook and created face profiles to friend. Fact. Watkins is unstable. Potentially mixed fact opinion. Watkins also filed her own declaration detailing statements that she contends Miller had made about her and swearing the statements have been false. Well, this is going to be interesting because Watkins is in a weird position because Watkins can either do one of two things. She can communicate things she directly heard herself, which is not defamation, because you have to communicate to a third party. So if the reason Watkins knows these things is because Miller herself told Watkins, it's not defamation because it's not communication to a third party. If she learned it from other people, it's hearsay. Right? So, this person told me that they told them. Right? So sometimes the hearsay rules on introductory matters sometimes vary, and I don't know them precisely enough, right? At trial, we know what the rules are, but sometimes in preliminary stages, courts can be a little bit more loose, and sometimes it's obviously defined by formal rules and formal case law, so it's not like completely open, but sometimes hearsay can be acceptable for, prima facie reasons or other reasons. So it depends on a whole host of reasons. But we'll just simply note that they're hearsay without getting into whether or not they're permissible at the moment. Also, there's 3 bajillion hearsay exceptions, so there's that. Beginning in August 2019 and continuing to this day, Carlisle Miller has made false claims about me and continues to send these false claims to others. Hearsay. I'm aware she's made at least these following false claims. How? That I took everything out of my bedroom. That my daughter doesn't want to live with me. That I don't need to be and shouldn't be around Brockett. My children are not safe. I stalked Carlisle Miller. Stalked my ex-husband. Unstable, insane, and mental. I bullied children. I stalked Carlisle Miller. I have a criminal record. I have a CPS record. That I should not be in my position. I'm not fit to be at the school. I'm dangerous, abusive. I abused my own children. Troublemaker. Liar. That I'm not allowed to teach. Investigator with the police that told me to stop harassing. That I should have my old children removed. That I took away cheer from her. I don't even know how you would prove or disprove that. How would you prove or disprove you took away cheer from somebody? Can you measure cheer? I don't even know. I mean, it's not really an opinion because it's like claiming a fact, but how do you measure that? I'm not sure. I've been hurting Carlisle Miller and her children for years. I slander Carlisle Miller, lied about her others, that I'm an evil mother, bully her daughter, that I'm hurting everyone and bullying Carlisle Miller. I interfered with the cheer situation. Apparently she's been accused of interfering with the cheer situation. Okie doke. The police told Miller that what I said was not true, spoke lies and slanders. So yeah, either she knows it directly because it was communicated directly to her, or it's all hearsay. So I'm not really 100% sure on the value of this, But maybe the court will get into that. Maybe the court will explain to us how hearsay is evaluated in preliminary stages, so we could learn something there. Both the other parents who signed declarations stated the matters they described were brought to their attention by Miller and not by Watkins. Okay, what do you mean by brought attention to? That's key. Are they relaying things they themselves saw or things they themselves heard? Because if it's coming from Miller... Wait, no. Let me get this right. Oh, it's brought to their attention by Miller. Okay, wait, no. Hold on. I'm losing the plot. Statements Miller had made. Carlisle Miller. Okay. Carlisle Miller is the potentially bad person. All right. So both the other persons stated that these things were Watkins, and if Watkins did not stop, Miller was going to have to take this to the next level. Well, she either said that or not, right? One parent also stated in response to parent statements asking Miller to cease making statements about parents. Miller responded she had the right to do so, and this is how she retaliates. It may very well be how she retaliates, but that doesn't make it legal. Okie doke. So we've learned a little bit about hearsay. We've learned a little bit. We've analyzed some statements, at least off the cuff, about statements that are potentially factual, potentially opinion, some mixed fact and opinion. We apparently have two witnesses who the defamation was brought to their attention by the defamer. So that works, right? And they've observed a whole bunch of statements that was brought to their attention by the defamer. So that works. I'm not sure what value Carlisle's declaration has, but we have two witnesses who apparently observed it. So that sounds like prima facie evidence. So I'm like, I can keep reading, and I will keep reading, but it sounds like prima facie evidence to me. So I'm not sure this is going to teach us anything by the time we're done, but we'll keep going. And Nova Zero has said, has there been a deposition in this? No, there was no depositions because I don't know that for a fact, actually, but I'm going to assume because it wasn't mentioned. The TCPA puts a discovery freeze on when it goes in place. And depositions happen during discovery. So I'm going to assume there were no depositions set. However, there apparently were affidavits/declarations, which don't require discovery, right? You can just attach them as part of the original complaint. And was one of my criticisms of how Ty Beard handled situations. And, well, he tried to attach declarations, but of course he screwed up the notarization process, and then he screwed up the second amended, and they may not be on the record. So they may not exist. But yeah, you can... Did depositions happen? Almost certainly not. But declarations, affidavits, sure. In response to Watkins' suits, Miller made a general denial and then a motion to dismiss under the TCPA. And TCPA is kind of just a motion to dismiss. It's a special motion to dismiss with its own special rules. The exhibit attached to the motion to dismiss were a copy of the divorce decree between Watkins and her ex-husband and brief affidavits executed by Miller and her husband. Okay. Miller's affidavit stated that Watkins had inappropriately involved Miller's daughter in disagreements with that Watkins had with her ex-husband, that Watkins harassed her, that Watkins created fake social media accounts to spy on her, that Miller had met with school officials to discuss her concerns, and Watkins had never discussed these concerns, but had sued her without warning. She's under no particular obligation to discuss things with you before suing. Right? I mean, it's not exactly unheard of for people to give a cease and desist or otherwise try to intervene before filing suit. But, you can just go straight to skipping suit. She never talked to me before filing suit. I'm like, who the hell cares? That doesn't matter. What are you talking about? Miller's declaration also described Watkins' criminal history. Watkins responded with the declaration evidence we've outlined above. At the time she filed the response to the TCPA motion dismissed, Watkins also filed a first supplemental original petition that augmented the factual allegations of her original petition by, among other things, explicitly pleading Miller's alleged defamatory statements that Watkins had cataloged in her declaration. That's a nice trick. That's a nice trick. I like that very much. So you get an amended pleading for free, And so she amended her own original complaint by specifically claiming elements of defamation that the alleged defamer put in their declaration. I like that very much. Now, because it's like, yes, I've said believe the following things. Like, okay, I'm going to claim that you said believe these exact specific things you've already sworn to. Right? Pretty good idea. Now, of course, that doesn't mean that they're defamatory. They could be true. They could be true. They could be in a privileged context. It might not be negligence. Maybe it's a matter of public concern. We could get into that. Maybe. Debatable. Because we have a volunteer for the school. And so maybe who volunteers for school, there's some quasi public figure analysis in there somewhere. Maybe. But yeah, so we're not saying it's defamatory, but, claiming that she said these specific things when she herself is sworn to saying these specific things is a pretty good strategy. The trial court conducted a hearing on the motion to dismiss, as they did in the Vic Mignogna case. The one in the Vic Mignogna case didn't go that well. We did a live reaction to that. It was a train wreck for Ty Beard. The trial court then entered an oral ruling over the objections that each party filed to the other's evidence, presumably hearsay would be once amongst them, and entered an order denying motion to dismiss. Well, it seems like we have enough, even if we are going to throw out some of this evidence, it seems like we have enough evidence to proceed. So, yeah. The trial court made the following facts. Okay, great. Let's do that. Miller satisfied her burden of proof under the Texas Citizen Protection Act. Whether Watkins is a public figure for a limited person is a question of fact. See, I told you, right? Public figure or public concern, right? So Watkins is maybe a public figure because school volunteer. Maybe it's a public concern because school volunteer. So, yeah. Yeah. Watkins has satisfied her burden of proof to proceed on her causes. Yes. Submitted sufficient, admissible, clear, and specific evidence of each element. So this is also the one where Vic Mignogna is really, really tripping over, is this problem. Because for those of you who may not remember the Vic Mignogna case, so I think there was a second amended, as memory serves. I think there was an original complaint, a first amended, I think a second amended. I'm pretty sure. So in the original complaint and the first amended, it was very unspecific. It was very conclusory. It was very notice pleading, which is permissible, but the Texas Citizen Protection Act or Participation Act, I always get that confused. Participation or protection. Does it really matter? No, but I get ragged on it every time I mess it up. So you don't even know what it stands for. Yeah, me knowing what it stands for doesn't preclude my legal analysis. So yeah, sometimes I forget what it stands for. But anyway, where was I? I lost my train of thought. The sufficient, admissible, and clear and specific evidence. So the clear and specific evidence factor. So yeah, the original complaint and the First Amendment didn't contain any really stuff. And then Ty Beard, who represented Vic, tried to file a second amended, which contained a whole bunch of stuff, but may have come in too late, may have been improper, and so forth and so on. The trial court seemed to not allow the second amended. And that may have been a proper decision. We will learn in the future, I suppose. But yeah, it feels like a proper decision. He filed it like right. He filed the second amended in the Ty Beard case. He filed the second amended. What was it? It was like a week, or maybe it was a little bit less than that. It was something in that time frame. It's like a week, or maybe it was 5 days. Maybe it was 8 days, something like that, before the hearing on the TCPA. And the judge might have the discretion to not allow that, because usually you get one amended for free. And so the judge might say, we're having the hearing in 7 days. It's not enough notice. I don't want to hear this right now. And the judge does tend to get a lot of discretion over their own court. So yeah, the Second Amendment didn't come in, so all that wonderful specific stuff didn't come in. So basically Vic was screwed. Yeah. Without finding whether Watkins was a public figure for a limited purpose, as we discussed, the admissible evidence submitted by Watkins is sufficient to overcome a motion to dismiss, even under the heightened standard of proof. So the heightened standard of proof for public figure. Now remember, this is prima facie, right? The court isn't concluding this is true. It says it's sufficient, potentially, possibly, maybe, to overcome the heightened standard. So for a public figure, public concern, right, we have to have actual malice. Is there enough evidence that could possibly suggest an actual malice? Is it possible? Yes, it's possible. Is it there? I don't know. I don't know. So we don't know whether or not she's a public figure. We don't know whether or not this is a public concern. But even if it is, there's enough evidence to possibly suggest it's enough. We're under a pretty low standard here, all things considered. You have to provide clear and specific evidence. So the evidence has to be clear and specific, but it only needs to meet the prima facie burden. So that's the key, right? You need to be able to meet the burden of proof. It just needs to be of a clear and specific nature. It can't be general. It can't be vague, which was Ty Beard's problem in Vic Mignogna, for the reasons we stated. Right? But here, we made a lot of very clear statements, very specific. She said this, she wrote this, she did exactly this. Very clear, very specific. Prima facie? Sure. Why not? Will it ultimately survive at the end of the day? Who knows? Because we're not trying to solve that problem right now. So Miller files a notice of appeal under the TCPA saying that the trial court got it wrong. It looks suspiciously to me, based on the Court of Appeals telling, that the trial got it right. All right. The TCPA states its purpose is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of persons to file meritorious lawsuits for demonstrable injury. It's your classic anti-SLAPP law. Well, I don't know about classic, but it's an anti-SLAPP law nevertheless. The Act's framework utilizes a three-step process to resolve whether a claim is subject to the rules of the TCPA, and if so, whether the claim should be dismissed or allowed to proceed. The three steps are as follows. The party invoking the anti-SLAPP TCPA must demonstrate that a legal action has been brought against it that is based on or response to the exercise of free speech. Yeah, I mean, that clearly is true, right? This is related to speech. So you got that easily. Act 1, Part 1. Part 2, if the moving party successfully invokes the act, the court may not dismiss a legal action under the section if the party bringing legal action establishes clear and specific evidence of a prima facie case, right? So you only have to make the prima facie case. So it's more than mere speculation, more than mere conjure, more than a mere wisp up a possibility. You know, it has to have some kind of probability. So what is prima facie? It's kind of like probable cause. What's probable cause? Let's say it's a 20% certainty. Let's say it's 20%. I don't know. Something like that. So, but here you need to, but see the difference in the TCPA, right? Because we've mentioned this. The difference in the TCPA is in the normal lawsuit, you only have to provide a notice pleading. You don't have to provide clear and specific. You can just make general allegations. They did stuff. But in the TCPA, you have to be, what specific stuff that they did? It's a little bit like a suit for fraud, which also has similar requirements, incidentally. So if you want to sue somebody for fraud, specifically fraud, you have to provide more than just notice pleading. You have to provide more, you have to provide specific stuff in the original complaint. So it's not the only example of this, it's just an example where it requires more than notice pleading. So it requires you to provide something more clear and specific. Yeah, so fair enough. And if the non-moving party carries its burden, the case may dismiss if the moving party establishes an affirmative defense or other grounds on which they are entitled to a judgment as a matter of law. And that would be, for example, failure to clear the burden under Sullivan, but the court says, yeah, maybe 20%, 15%. I mean, that's all we need at this stage. 15%, 20%, 10%, something along those lines. Something more than mere speculation, something more than a wisp of possibility, something more than just conjure. 10%, 15%, 20%, something like that number. So do we have 20% certainty that she'll clear the Sullivan standard? Sure. Why not? Will she get to 51%? Who knows? In this appeal, we assume that Watkins' suit was brought in response to Miller's exercise of rights. I think so. I mean, it clearly is. This is clearly a related speech, so element number 1 is met without blinking an eye. Our focus is on the question of whether Watkins carried the burden of the step on to present clear and specific evidence, a prima facie. I mean, yeah, one would imagine. We conclude that Watkins did. We begin our discussion by describing the special body of law that has been developed in response to defining the prima facie burden. So, yeah, like everything else, this has case law on it, which will inform our analysis. That helps to define these specific things. Okay, great. To present a clear and specific evidence, the non-movement must provide enough detail to show the factual basis for its claim and must provide enough evidence to support a rational inference that the allegation is in fact true. Right? So, yeah, that's basically what we've been saying. Clear and specific is clear and specific. Specific. What exactly did they say, or write, or do? And could you be, like, not vague about it? Yeah, that clear and specific means clear and specific. Yeah, okay, great. The words clear and specific are defined to mean, for the former, unambiguous, sure, free from doubt. We know what you're talking about. And for the latter, explicit, relating to a particular name of thing. So by clear and specific, we mean clear and specific. The party responding to the TCPA motion to dismiss may rely on circumstantial evidence, indirect evidence that creates inference, unless the connection between fact and inference is too weak. So circumstantial evidence is valid, but you have to be clear and specific about the nature of the circumstantial evidence. What is it? The non-movement surrounds its burden of establishing prima facie when the evidence presented is sufficient as a matter of law to establish a given fact if it's not rebutted or contradicted. Yeah, so again, this is the standard for pleadings in general. We assume everything the plaintiff says is true. We know this, right? We assume everything the plaintiff says is true. Unless it's palpably ridiculous. Unless. But yeah, basically 90% of the time, we take what the plaintiff says is true. Right? 95% of the time, we take what the plaintiff says is true. There are minor exceptions, but yeah. So everything the plaintiff says is true. Did they provide clear and specific things that, if true, would make them win? At least to the prima facie standard? Yeah, that's easy enough, right? The only thing the TCPA is really doing here is making it from notice pleading to non-notice pleading. That's really all the TCPA is doing in this particular aspect. It's doing other things in other aspects. But all it's really doing in this particular aspect is changing the requirement from notice pleading to non-notice pleading. Now, what makes it a little bit interesting is that the defendant is the one that invokes TCPA or not. So the plaintiff can file the original motion for defamation with notice pleading, right? Because that's the standard rule. Standard rule is notice pleading. And then the defendant comes in and says TCPA. And if TCPA is successful, that means your original pleading is defective. So you can do one of two things as an attorney in this domain. First of all, you can be sane and preempt the problem, right? So you could just put it in your original complaint. So if you're arguing defamation, if you're arguing defamation, you could just be in your original complaint, provide some specific stuff, right? Why not just be clear and specific in the first instance? I mean, if you're an attorney in Texas, you should know about the TCPA. And you're thinking to yourself, I'm going to file a defamation action. A potential thing my defendant might do is file a TCPA. So why don't I head it off at the pass? Why don't I just put it into my complaint? Now, I don't strictly speaking have to at this stage, but I will have had to. So why don't I just do it now and save myself the effort? Or the other alternative is, of course, you file an amended pleading after they file the TCPA. But why? I can't think of any particular reason or advantage to not just claiming the specific stuff in the first instance. Why not just put it in your original complaint? Why not just put it in your original declarations that you attach with the complaint? Why not head it off at the pass? I don't know. But yeah, so you have to, kind of like a fraud complaint, you have to just provide specificity. You can't do notice pleading. Great. Easy enough. Statements that are conclusory or evidence that's speculative doesn't work. Yeah. So things that are conclusion, no. Things that are speculation, no. No. You actually have to have, evidence. Prima facie evidence even, right? Beyond the mere wisp of a possibility, beyond mere conjecture, beyond blah, blah, blah. So yeah, evidence that's speculative is not prima facie. Right. Deep. Wow. Overall, we review a trial court's denial of TCPA motion to dismiss de novo. It's a legal conclusion. In reviewing this ruling, we view the pleadings and evidence in the light most favorable to the non-movement, as you do. Right? What are the facts? The facts are whatever the party who's not asking for it says. This should sound really, really familiar to you guys. Everything the non-moving party says is true for the purposes of this exercise. Those are the facts. Great. What is the law? Let's figure it out now. Great. Okay. So there's 4 elements of defamation. Yeah. Okay. Miller's first issue makes a variety of arguments attacking the trial court's denial. As the parties do in their briefs, we concentrate on the question of whether there's prima facie proof of each element of defamation. The Texas Supreme Court has recently stated the following elements of defamation. Okay, so Texas phrases it as publication of a false statement of fact to a third party that was defamatory concerning the plaintiff, which is kind of implied, incidentally, because otherwise what's standing? So the defamatory concerning the plaintiff, I'm thrilled and all that Texas stated it explicitly, but it's kind of implied, because otherwise why would you have standing? With a requisite degree of fault, right? Negligence or others, and damages. This is basically the same standard of defamation I've been telling you forever, right? It's a false statement of fact communicated to a third party in a non-privileged context. And then, of course, damages, unless it's defamation per se. What is a defamatory statement? Well, a defamatory statement is one that tends to harm one's reputation or deter third persons from associating or dealing with them. But remember, facts. False statement of facts. In order for a party responding to the TCPA to dismiss to make a prima facie case, the party's pleadings and evidence must establish facts of when, where, what, the defamatory nature, and how they damaged. Sounds perfectly logical to me because of clear and specific, right? Who, what, when, where, why? How are they defamatory? Like, what is false about this? They stated I'm a convicted criminal. I'm not. They stated that I was barred from seeing my children by CPS. No. Yeah, so that makes sense. Nothing surprising there. We initially explained how to approach the review of whether Watkins established prima facie case for defamation. As the 14th Court of Appeals recently explained, we're not required to determine that each and every statement that Miller has made is defamatory in order to conclude they meet their burden. Right. Correct. Right? We don't need to prove that every statement is defamatory. We only need to have one. One statement of defamation is enough. So as long as we can find one, we're there. And I went through the analysis in my opinion. I excluded a whole bunch of things as fact. Or apologize, I excluded a whole bunch of things as opinion. But did I find things that were factual? Yep. No problem. Is there some suggestion that they're false? Yeah. I mean, that's what they're arguing. Were they communicated to the third party? Yep. Is it in a privileged context? Not all of them. Maybe to the government, maybe to the principal, but not to random people. So do we have at least negligence? Do we have at least actual malice on a prima facie standard? Sure. We should go forward. I have no problem with this. Instead, the inquiry is whether Watkins presents sufficient proof to establish a viable cause of action, and task requires only what we determine, where in the statements made by Miller were defamatory. As the 14th Circuit has explained, while the TCPA requires that each legal claim be analyzed individually, the TCPA does not require that each factual basis or theory of recovery underpinning it must be analyzed separately. Right. So you can have one cause of action that has multiple different independent bases. I was defamed because of this thing, this thing, this thing, this thing, this thing. You could bring those as separate causes of action. You can bring it as one cause of action. And so we don't have to analyze each one individually. We have to analyze each claim individually. So we have to figure out whether there's defamation. But for the defamation, we only need to find one basis. One basis would be enough. Anything extra than that is gravy. Here, appellees have made a single defamation cause of action. So there is one defamation cause of action, which is based upon statements, lots of statements. In a flyer, this is going back to the prior case, by the way. This is talking about the precedent, the case law. It was based on a precedent in a flyer that they publicly distributed and a sign they publicly displayed. So there's a flyer and there's a sign. Two things. If appellees are successful in presenting prima facie proof in support as to any of the statements in the flyer or the sign, flyer or sign, they met their burden. The sign was defamatory. The flyer was defamatory. Great. Do you have prima facie evidence of either? Great. Then you have a cause of defamation. We don't need to figure out the other ones right now. One is enough. The TCPA does not require appellants produce evidence that each and every statement in the flyer, for the prior case, is defamatory to meet their burden. One is enough. Rather, appellants must establish a prima facie case for each essential element of defamation. So if you have 50 different things that are defamatory, you need to prove one of them to a prima facie standard in clear and specific terms. Thus will highlight certain statements made and while we conclude they're defamatory. And this again would be on a prima facie standard, right? So the Court of Appeals only needs to find one, that they find there's prima facie evidence of defamation. That's clear and specific. Great. The principles that guide this determination whether Watkins has established prima facie proof of the first element is as follows. Did Miller make a statement of fact? This turns on whether a statement is verifiable. In other words, can it be proven or not? Is it capable of being proven? If a statement is not verifiable as false, in other words, if it can't be proven, it's not defamatory. Right. Did Miller publish the statements? Did they communicate them to a third party? Publication occurs if the statements are communicated orally or in writing or print to some third person who is capable of understanding them. I guess we never explicitly mentioned that in our defamation roundup. Yeah, you do actually have to communicate them to someone who can understand them. So if you communicate them to your 3-year-old child, probably not so much. So yeah, that technically is a third party, but no, you have to have someone who's capable of understanding it. So I guess we kind of skipped over that element, but fair. Were Miller statements false? Are they capable of being false? Are they false? We assume Miller statements involved a matter of public concern. We're assuming that, right? Because that's the elevated standard, right? It may not be a matter of public concern, but we're going to assume the worst possible case, legally, right? And follow the precedent Watkins said. Okay, so we're going to have to find actual malice to a prima facie standard under clear and specific evidence. A number of Miller statements were statements in fact. Her statements that Watkins had created Facebook face profiles, had stalked her, and had done things, such as punishing her daughter by making her sleep on the floor, for associating with her daughter by making the child sleep on the floor, are verifiable. They can be proven as true or not true. Did she create false accounts? Did she do these things? Did she make her child sleep on the floor? Those are potentially verifiable. Seems logical to me. Miller published the statements. The record contains declarations of 2 other parents stating that Miller had referenced Watkins and they understood the defamatory context of these statements. Certainly, Miller specifically identified Watkins' intercommunications to school officials and to the police. Nothing suggests that those recipients were incapable of understanding the potential defamatory content or can misconstrue. So the Court of Appeals is kind of glossing over here the communication to the public officials element, because that can get a little bit tricky. But we can forgive them because we have communication to 2 other parents. So even if the communication to the police and school officials is protected in some way because it's communication to the government, the 2 other parents is enough to move forward. And again, remember, we only have to find one thing. So we don't really have to worry about the school officials at this exact second. But they do kind of gloss over the issue. With respect to falsely, Watkins stated they not stalked Miller's social media accounts or had abused her daughter. So Watkins said, these are false. I didn't do those things. Great. In essence, at the TCPA motion dismiss stage, this is a case of he said, she said, in which party one claims they occurred and one claims they do not. Correct. Right. This happened. No, it didn't. We take everything the non-moving says is true. Everything the non-moving party says is true except asterisks. And if they say it's true, then, and they have other witnesses backing them up, bonus. Well, actually, in this case, probably necessary, because I don't think a declaration from Watkins is really going to work in terms of she can testify as to whether it's true or false. In fact, only she can testify as to whether it's true or false. But she can't communicate about whether it's defamatory because she can't be a third person. So she can provide half the equation. The nature of the acts is such that we do not know what proof Watkins could be expected to produce at this point in order to prevent prima facie other than to deny the acts occurred. Yeah, so we don't know if Watkins could provide any evidence that it's false or evidence that it's not true. And there might be evidence that it's not true, like there is no report. There is no, my daughter will testify it didn't happen. I have surveillance cameras, so it's possible she has evidence that might go against it. Do we care at this stage? Of course we don't. Of course we don't. Because we take everything the non-moving party says is true. So she might very well have evidence that will win her the case. Do we care at this moment? Nope. Miller provides no specific evidence to document that Watkins had created a false profile to troll her on social media. She simply asserts Watkins had done so. We're unsure. Okay, so Miller's provide no evidence to document that Miller created false profiles to troll her. And the only unstruck record reference to trolling was some unspecified statement. We know nothing about the age of her son. Okay, great. We're unsure how Watkins would prove the negative. She had not created social media accounts at this point in litigation when Miller's statements provide no particulars on how she done so. Yeah, I'm not exactly sure how you would necessarily prove the negative. I mean, testimony is evidence. So there's that. She can say it didn't happen. How she might go about proving she didn't create social media profiles, I'm not sure. Browser records. Maybe she can get a subpoena from Facebook to show IP addresses that aren't hers. There might be ways, but maybe she can prove it. Maybe she can't. Do we care? Not really. Miller also claimed Watkins had punished her daughter in a particular way, and Watkins also presented proof she had not taken actions that Miller claimed regarding punishing her daughter. Do we care really at the moment? Not really. Our situation is similar to the one we faced in Van der Linden, a case in which a defendant allegedly said plaintiff had given the money to a terrorist organization, and plaintiff denied they made such statement. We noticed in this situation, where there are only two parties to the communication, plaintiff could do no more than deny they made the statement. Yeah. So, right. So in the situation where there's only two people, when you have an oral statement, right? When you have an oral statement and it's in a hotel room, as I believe it was in that case. No, that was Vic Mignogna was in a hotel room. I don't remember their context, whatever. But if you only have an oral statement, so it's not recorded anywhere, the only evidence you could provide, and there's only two people there, the only evidence you could provide is your denial. But it's enough to contest it. I mean, it's not like rock solid proof like an alibi, but yeah, I mean, the only evidence you can offer to deny is the denial, which is enough to argue that it's false, right? So a lot of people in the Vic Mignogna case, because there was an incident in which Vic Mignogna said it was in a hotel room. Yeah. Because Vic Mignogna was accused, if memory serves, of sexual assault or sexual impropriety in some way in a hotel room with one of his co-stars or co-actors. And obviously, the only two people that would be there would be Vic Mignogna and the potential victim. There wouldn't be any writing. There wouldn't be any recording, presumably. So all Vic Mignogna can do is deny it, right? So he can say it's not factually true, which creates a contest. But he still has to make clear and specific evidence. And as I mentioned, right, all the clear and specific evidence was attached to the second amended. and the second amended wasn't entered, or it appears it wasn't entered. And so, yeah, so that's a problem. And it wasn't entered, at least in part, because it looks like the trial court, because the trial court was vague. This is Vic Mignogna's best hope, as I see it. The trial court was vague, so they could send it back to clean it up. So that's Vic Mignogna's best chance of winning. It still seems to me, right? So the best chance of him winning is kind of a Pyrrhic victory. The court of appeals could say, like, the trial court was vague about what it was doing. It was unclear as to whether it was striking the Second Amendment. It was unclear as to this, unclear as to that. So that's like Vic Mignogna's 10% chance of winning. But even then, it's like, it's a Pyrrhic victory. There's only like a 2% chance of him winning in a way that matters. So yeah, on a 100% scale, there's a 90% chance he's going to lose. There's an 8% chance he's going to win in a way that won't matter. And there's a 2% chance he's going to win in a way that's going to matter, the way I've calculated the odds. So it's not looking very good for Vic. So if the Court of Appeals winds up reversing this, and they wind up reversing this on technical grounds that are not going to matter, I'm going to enjoy the battle between me and the chats at that time of me explaining to them that I technically wasn't wrong. So like you said, Vic Mignogna would win. Yes, I also said many times that his best way of winning would be in a way that won't really matter, and this is it. I didn't think it did enough for me. Like, I thought it was clear enough. But the Court of Appeals could disagree with me. They're like, yeah, there's a 1 in 10 chance they could disagree with me. I didn't think it was that much a problem, but, the Court of Appeals could say, yeah, it wasn't clean. But if they're going to send it back just to clean it up, what's the point? That was my argument of why they wouldn't do it. Right? That was my argument of why they wouldn't do it. Because if the only issue was if the trial court was a little bit vague, and you're going to send it back merely to clean it up, only to wind it back on appeal and be like, now that it's clean, we know what the answer is. But if you already know that in advance, why bother? So it's like, why not just because the Court of Appeals can make the inferences. They can, and usually do, analyze judgments in a way that's most deferential to the decision below. So usually they look for reasons to justify the decision. So if the only reason you'd be sending it back is for technical cleanup, why? Why not just fill in the gaps yourself and be done with it? So I figure there's a 90% chance they'll rule against Vic, because why bother? There's an 8% chance they'll say, okay, go back and clean it up, make these findings clear. Now you can appeal again, and we'll just tell you you're wrong. And then there's a 2% chance that it's going to be a substantive decision in some way that's going to actually matter. So the best chance for Vic, the best chance for the 2%, and that would blow my mind, the best chance for Vic on the 2% is to say the trial court abused discretion by not entering the Second Amended. That's the best chance that they have. And I figure it's about a 2% chance of that happening. If that happens, it will blow my mind. Yeah. I can see the possibility. So I acknowledge the possibility, but I'm like, there's like a 1 in 50 chance. So if the Court of Appeals says the trial court committed reversible error by not entering the Second Amended, well, at that point I'll have to eat some crow, quite a bit of crow at that point, because I'm like, I predicted well against that one. So if the Court of Appeals winds up reversing the Vic Mignogna case for technical reasons, I'm going to feel smug, even though the chat is going to feel smug. So the chat will feel smug, but I'm going to feel more smug. If they wind up reversing because the trial court committed abuse of discretion, then the chat has my permission to feel smug. Because I didn't see that one coming. So yeah, I acknowledge the possibility, but I was like, I don't see it. So if they wind up reversing because the trial court committed abuse of discretion by not entering the Second Amended, well, I'll have to eat some crow on that one. All right. The elementary question establishing that the statement is defamatory turns on whether it tends to harm the reputation of another as to lower him in the estimation of the community or deter third persons. Whether a statement is defamatory is a legal question. To analyze whether it's readily capable of being understood as defamatory poses the following questions. Whether the meaning the plaintiff assigns to it is reasonably capable of arising from the text. Is the defamatory understanding a reasonable understanding? And whether the meaning ascribed to the statement, if the meaning is reasonably ascribed, is capable of defaming it. So, is the statement capable of being understood, and if it did, would it defame? The Texas Supreme Court recently established new categories to address these questions and abandon, among other than for the purposes of presuming general damages. The long-used categories of defamation per se and per quod are descriptors of whether a statement was defamatory by its text alone. Okay. So the Texas Supreme Court has apparently abandoned per se, per quod. So there was these idea of per se. Okay, so they're in common law. There's defamation per quod, which is just your normal defamation. And then there's a couple, in normal defamation case, you have to prove damages. But there's some exceptions. There's these per se things that if you prove, you don't have to show damages. And a common law included things about a person's profession, things about a sexual proclivity, things about disease come to mind. So these were common law. But apparently the Texas Supreme Court has done away with that. Okie doke. So that's notable. We've abolished the common law in this respect. The Supreme Court established two broad categories of statements with distinctions between the two, turning on whether the face of the statement contained potentially defamatory sting, or whether the sting could be found only if extrinsic evidence. So our two new categories are not between what the speech concerns, which is the old law, right? So if it was about sexual proclivity, that's what the speech concerns. But we're not doing that anymore. Now we're doing whether it's defamatory on its face or whether it requires something else. Okie doke. The two given categories to correspond to their level convey meaning or with or without resort to extrinsic evidence, with the category not requiring extrinsic evidence being textual defamation, other one being extrinsic defamation. I don't know what difference, if any, it makes. Does it make a difference? I mean, it changes like the nature of what you have to show in the practical matter, because if it's defamatory on its face, you don't need to like show any evidence. You just show the statement. But if it's extrinsic, you need to show something external. So it changes the nature of the evidence, but does it change anything else? Because in the old distinction, it mattered because you didn't have to prove damages. So you actually had to not prove an element at all. As further breakdown, textual defamation contains two subclasses. The first is an explicit textual defamation. Explicit textual defamation needs no interpretive effort to discern the point the defendant is making. The Supreme Court describes such statements as being where the statement's literal text and communicative content align, where the statement says and what the statement communicate are the same. In other words, it's both textual and explicit. Okay. The second category is implied textual defamation. The category requires interpretation. To unearth whether a statement contains implied meaning, a judge reviews the statement from the perspective of an objectively reasonable reader who internalizes all the reasonable implications. So we're alluding to it cleverly, I guess. The court viewing the statement from this perspective must parse the statement and apply this test. If a communication viewed in its entirety merely conveys materially true facts from which a defamatory influence can reasonably be drawn, libel is not established. Right. If it merely conveys true facts, then, they're true facts. But the communication by particular manner or language in which the true facts are conveyed supplies additional affirmative evidence suggesting the defendant intends or endorses a defamatory inference, the communication will be deemed of capable meaning. So basically, this is if all they are is true facts, then no. But this is kind of the same concept as the mixed statement of fact and opinion. So when you're stating, this is similar to it, where you're stating something that appears on its surface to be an opinion, but the opinion implies facts. So same kind of idea. The mere facts in this case are not enough, if true. But if you're, so it's kind of almost the reverse of that. So you had the pure statement of opinion, which implied facts. Now you have the pure facts, which implies a negative interpretation. So it's kind of like the reverse of that in some ways. That's kind of neat. In this case, we need not go through the process of drawing out implicit meaning. Right, they seem kind of defamatory on their face. I made my child sleep on the floor. Right, it doesn't require a lot of extrinsic evidence to understand what it's talking about. The statements of focus are what Watkins had created false profiles and had misused the social media, and Watkins go to length of punishing their daughter. Yeah, kind of clear on its face. We don't need to go through a lot of innuendo and implication. Kind of clear what it means on its own terms. Our second step is to determine if Miller's statement was capable of a defamatory meaning. Yeah. The Supreme Court offered the following broad guidelines. In Texas, a statement is defamatory by statute if it tends to injure a living person's reputation and thereby expose the person to public hatred, contempt, or ridicule, or financial injury, or to impeach any person's honesty, integrity, virtue, or reputation. In addition, under our state's common law, a statement is defamatory per se, which apparently we're not doing anymore, so I'm not sure why we're mentioning it, is when it's so obviously harmful that general damages are presumed. For example, accusing someone of a crime, having a disease, or engaging in misconduct contains defamation per se. I told you guys, right? I told you those things. And business reputation is another example. Moreover, remarks that adversely affect the person's business. See, it's always fun. It's always fun when I haven't read to the next sentence, and then I read the next sentence that just says the exact same thing I just said. That's always kind of fun. So like 2 pages ago, right, 2 pages ago or something, I said, okay, here's what defamation per se is. Defamation per se is these kind of statements when you defame sexual character, disease, business reputation, right? And then 2 pages later, the Supreme Court of Texas says, here's what defamation per se is. And they added a 4th category of crime, which I forgot. But it's like, well, first of all, this proves a couple things. One, I actually know what I'm talking about, right? Because I got there 2 pages before the Supreme Court of Texas does. And it's just funny. It's like, oh, and also, by the way, business. And literally the next line is, oh, by the way, business. So I was like, yeah, it's kind of funny when that happens, I guess. Relevant to the facts we analyze, an accusation of child abuse is an accusation of a crime. And to use outdated parlance, because we're not doing this anymore, for some reason, defamation per se. Which presumably means we always have to prove damages now in Texas? I guess. Further, in Texas, it's a crime to engage in online impersonation. The elements of this offense are as follows. A person creates the offense of if the person without obtaining the other person's consent. So first of all, you have to impersonate another person who exists. So if you're impersonating fictional people, then no. And with the intent to harm, defraud, intimidate, or threaten any person, uses the name of another person to create a web page or post social media. So yeah, you can't use someone else's name that exists, harass people. The 2 statements made by Miller we focus on are reasonably capable of defaming. To claim a parent goes to the lengths of making a child sleep on the floor, to punish a child for associating with another child, merely because the parent does not like the playmate's parents would, in our view, be an allegation of abuse that could involve both police and CPS. Note here, the court isn't saying it would be abuse. They're simply saying that it would potentially allow for investigation. This would be a basis for which the police could conduct an investigation. They're not necessarily saying it is that. They're simply saying it's alluding to that. And that's all we have to claim at this point, right? Because all we're having to say is that it's defamatory because it's a false statement implying a crime. And so it implies a crime because the Supreme Court says, yeah, this would be a basis for the police to investigate, so it implies a crime under a reasonable interpretation of what it says, right? Yeah, I probably could need it. I probably do need a new moderator. Who wants to be a moderator who's been here a while? So I can add a new moderator. Because we don't have one right now. We could use some new moderators. Who's been here a while and wants to be a moderator? The other parents who filed declarations stating that Miller had characterized Watkins as abusive and unsafe in treatment of the daughter, and her daughter no longer wished to live with Watkins. According to Miller's email, she needed to involve CPS because Watkins should not be around children. Indeed, Miller's brief argues that her comments were made as public concern because they involved acts of abuse that were reportable to authorities. Maybe. Possible. Also, Miller was open about making allegations that she wanted Watkins' presence removed from school. Thus, the statements had direct impact. Yeah, so whether or not they are statements of public concern, right, still has to be analyzed. We haven't gone that far. And also, we haven't necessarily said that these things would clear it. We simply are on a prima facie thing, right? So, Yeah, Ryan's been here a while. We'll add Ryan as a mod. That sounds fair. Further, Miller, the rules are be nice, stay on topic. And we are interpreting be nice with increased harshness these days because I'm tired of the bullshit and the drama. So time people out before blocking them, but be a little bit more aggressive than we've been in the past, please. Be nice to other people. Great. Further, Miller claimed that Watkins had committed acts that are accusations of crime on online impersonation. Though Miller later tried to assert that she had never filed a formal police report specifically accusing Watkins of a crime, she sent a police report to the school stating that she told the police she believed that Watkins had been creating Facebook profiles. In the report, Miller shared with the school police that they advised Miller of the law regarding online impersonation. There could potentially be a criminal charge if they had used this information with intent to harm. Miller made similar allegations to school and other parents. In essence, Miller published statements that Watkins had performed acts that could potentially constitute a crime, and then provided the school with a report from the police that outlined the nature of this alleged offense that might have been committed. Do you see all these qualifications at this point? You see how the court is really couching its language to make clear that it's not saying that any of these things are necessarily true or false? They're throwing a lot of qualification terms. I hope you guys are picking up. This could, maybe, potentially, possibly be a crime. We are definitely not taking a position on that at this point. We're simply noting that it could, theoretically, maybe, possibly, right? That's all we need for right now on the defamation thing. The parties dispute what level of fault should gauge whether Miller acted with the requisite degree of fault. Yeah, should we do negligence or should we do actual malice? Miller contends Watkins is a limited-purpose public figure. Maybe. Thus, Watkins carried the burden to establish she acted with actual malice. Maybe. Watkins disputes her status as limited-purpose public figure and argues she's required only to prove negligence. Maybe. We have to really get into it. Is being a volunteer at a school enough, either as a public figure or public purpose? We have to get into it. The trial court resolved this issue by finding that status as a limited-purpose public figure presented a question of fact and stating that without finding whether it's true, the admissible evidence could, theoretically, be enough to overcome this burden. So I'm not taking a position as to whether or not they're a public person, but even if there is, there's enough clear and specific evidence because we've been clear about who, what, when, where, why, how, right? We've been clear in our details. It's not ridiculous. It meets our 10 to 20% threshold that we're looking for. All that good stuff. We adopt a similar approach to that of the trial court and assume without deciding the heightened burden of proof of actual malice applies. We need not resolve it because there's prima facie case on our 10 to 20% standard, whatever we are within that range. That's what we're looking for. We're there. Because we assume Watkins bore the burden of presenting prima facie proof, we will be succinct in describing the mare's nest. Nice mare's nest? Do mares have nests? I'm not familiar with that phrase, mare's nest. Hold on, I have to Google that real fast. Mare's nest. Okay. What is the meaning of the phrase mare's nest? A much vaunted discovery, which later turns out to be illusory. What's the origin? The two unrelated meanings of mare's nest. There's a little connection. The first and proper meaning has been finding a mare's nest is imagining that one has found something remarkable when they found nothing of the sort. The second meaning, which is more widespread, is a mare's nest is a confused mess. So the phrase mare's nest means an illusion because mares don't have nests. So yeah, when I said do mares have nests, the very fact they don't is the point of the phrase. Okie doke, we've learned some more English today. How fun. We've learned a new colloquialism in our life. A new idiom. Okie doke. So we'd be succinct in describing this confusion of how courts describe what level of fault on the part defendant must be proven. The Texas Supreme Court describes how Texas law has evolved on this issue as a result from the United States Supreme Court. We have revised the elements of defamation cause of action in response to the United States Supreme Court's application of constitutional principles. Before Sullivan, which is New York Times versus Sullivan, the defamation plaintiff generally prevailed by proving defendant published a statement that defamed her unless they proved the truth. So yeah, it was a strict liability thing. But the Supreme Court held in Sullivan that freedom of expression requires breathing space, and if the plaintiff is a public official, they must prove actual malice. The court later held that public figures and limited purpose public figures must also prove actual malice, and the states may set their own level of fault for private plaintiffs. The court left the precise standard of fault to the states and chosen negligence, and we've chosen negligence for a private figure seeking defamatory damages, as most states have. I do think there are a few states that have strict liability, but not many. The court now conditions liable by a private person upon showing of negligence. The plaintiff who bears the burden of proving actual malice falls into three classes: public officials, general public purpose figures, and public figures for a limited purpose. No one contends that Watkins should have been characterized as a general purpose figure, which requires a person to have achieved some pervasive fame or notoriety, that they become public figures for all purposes in all contexts, which is a pretty hard trigger to pull. Instead, the dispute below was whether Watkins is a limited purpose, for which the party may hold public figure status for a limited range of issues surrounding a particular public controversy. This court has looked at three factors. The controversy at issue must be public, both in the sense that people are discussing it, and people other than the immediate participants in the controversy are likely to feel impact. The plaintiff must have more than a trivial or tangential role, and the alleged defamation must be germane. As all stated above, a public official may bear the burden of proving actual malice. Neither party addresses whether Watkins was a substitute teacher, which would make her a public official, for some or all purposes, maybe, or only at limited times, maybe. We need not decide that question, but observe there's a nationwide split on whether a public school teacher is a public official. So yeah, we're not, states have split on this issue. So apparently, we'll read this footnote because it'll be interesting. Arizona, Connecticut, Ohio, Oklahoma, Tennessee, and Washington hold that public school teachers are officials. States that hold the opposite: California, Florida, Idaho, Maine, New York, and Virginia. At least two Texas intermediate courts have held that public school teachers are not public officials. And so there seems to be some consensus as to no in Texas, but not definitive. Interesting. There's a split. Maybe someday it'll become a Supreme Court case. I'm not sure if that's appealable or not. I'd have to think about that. Because is someone a public official purely an issue of state law determination? That's a good question. Is whether or not someone is a public figure purely an issue of state law's determination? We're excluding here, by the way, public official. We're excluding here, but we're not into public figure. We're into public official. So that's governmental actor or not. Okay, so is whether or not someone is a public official, is that solely within state law determination? I mean, the answer can't be yes completely, because it can't be like a state can say the governor is not a public official. But they might have some boundaries that they can work within. Maybe it's like maybe some lesser officials are discretionary to the state. So maybe states can't determine that a governor is a public official or not, but they could determine as a matter of state law, whether a teacher is a public official or not. The idea of like a higher official or lower official. Maybe. Okay. All right, fun. As we've explained, the actual malice standard primary purpose is to protect media commentaries on matters of public concern. Here we deal with a controversy that began as a private email sent by one parent to a co-parent addressing a parenting concern about their daughter. That private communication was shared with a third party, and the third party viewed the statements in the private email as justification for creating a public dispute that involved other parents, school officials, and police. The actual malice standard seems a poor fit for a dispute between Miller and Watkins when that standard is calibrated to deal with media. Okay. Because the actual malice standard involves media behavior, the standard often involves determination whether the investigative work of media was done in a way that reveals actual malice. I don't know that I agree with their statement that it's calibrated to deal with media. I mean, media is the most often context, but I don't think that makes sense. They state that as a conclusion, and I'm not sure. The actual malice standard involves media behavior. See, the reason why I don't think that's possible is because it would imply that if you're non-media, it's impossible to defame a public person, which doesn't seem like it can be true. Or even a limited purpose public figure. Because if they're a limited purpose public figure, actual malice applies. If actual malice is solely a media behavior, then that implies that a private person cannot defame even a limited purpose public figure, which surely can't be true. These standards provide little guidance on what we've actually described as a he said, she said situation, which Miller claims that Watkins has abused her daughter by making her sleep on the floor, has trolled, and stalked social media accounts, in which Watkins asserts those claims are false. In this unique situation, we conclude the fact that parties' stories are so at odds with each other provide support and inference of actual malice. All right, I need to read that again, because something here is not tracking for me. I don't understand this. I don't understand this reasoning. The court's losing me here. The court's losing me here. The actual malice standard seems a poor fit when the standard is calibrated to deal with media. I don't think that's true. I mean, it's the most often context that's going to come up, but I wouldn't say it's calibrated to deal with media. And then they say because the actual malice standard involves media behavior, standard often involves determination whether investigative work of the media was done in a way that reveals actual malice. This doesn't make sense. If the actual malice standard necessarily requires media behavior, or the actual malice standard necessarily involves media behavior. If media behavior is required, then we could just stop our analysis and say there's no actual malice here. But the court is going to continue. These statements provide little guidance on what we've already described as a he said, she said situation. Miller claims that Watkins abused her daughter and stalked social media accounts, which isn't media behavior. So the court contradicts itself within the space of two sentences. The court says the actual malice standard involves media behavior. The next sentence should therefore read, because this is not media behavior, it is not actual malice. Instead, the next sentence reads, this is not media behavior, so we don't have much guidance as to how actual malice applies. but your predicate is actual malice involves media behavior. This is sloppily written. This is bad writing. Bad court. In this unique situation, we conclude the fact that the party story is so at odds with each other provides evidence supporting an inference of actual malice. At the beginning point, to say standards governing the actual malice determination are imprecise is an understatement. The standard turns on subjective awareness of the defendant, and the injurious motive impacts determination, though motive is not determinative. Yeah, you have to have some intent to, commit the act. It's an intentional tort. The Tyler Court of Appeals recently explained the parameters of actual malice. To establish actual malice, a plaintiff must show defamatory statement was published either with knowledge of falsity or reckless disregard. How many times have you heard me say that? Reckless disregard is subjective, focusing on defendant's state of mind. Mere negligence is not enough. Rather, the plaintiff must establish defendant, in fact, entertained serious doubts as to the truth or had a high degree of awareness of probable falsity. Doesn't this sound familiar to things you've heard from me? The evidence must be viewed in its entirety. That's true. You can't look at statements in isolation. You have to look at the statement in its entire context. Because the idea here, incidentally, is like a single sentence by itself might appear to be defamatory, but in the context of the paragraph, it's not. So that's kind of what they're talking about. Further, defendant's state of mind must be proven by circumstantial evidence. Yeah, because usually they're not going to admit to it, although we've seen that not to be 100% true. For example, in our Capitol Riot series, people will admit to all kinds of crazy shit. Specifically, the Supreme Court stated the following: a lack of care or injurious motive in making a statement is alone not proof. Yeah, because lack of care implies negligence. Injurious motive is not enough, right? If I desire to injure you, if my goal is to injure you, but I'm not reckless in what I say, then yeah. But care and motive are factors. Well, yeah, because if you lack care, it might suggest reckless, and if you desire to injure, it might suggest that you were disregarding the truth. Right? But they're not dispositive. They're informative, but not dispositive. An understandable misinterpretation of ambiguous facts does not show actual malice, but inherently improbable assertions and statements made on information is obviously dubious, may show actual malice. So if you misinterpret the facts, no. But if it's improbable, if it's obviously doubtful, yeah, maybe. A failure to investigate is not evidence by itself. Purposeful avoidance of the truth is, right? So reckless disregard of the truth doesn't require you to investigate. There is negligence, strictly speaking. But yeah, you just have to not purposefully be trying to avoid it. You can't keep your eyes closed and your ears shut. Or maybe the other way around, whatever. In addition, the Supreme Court stressed that proof of actual malice is not defeated by a defendant's self-serving prostitution of sincerity. Yeah, just because I'm sincere in what I say doesn't mean that I didn't communicate false facts and so forth and so on, right? So my lack of desire to injure you is also not dispositive. It's at best informative. So the desire to harm you or not is informative, not dispositive. Actual malice must be cleared by clear and convincing evidence. That's a higher standard of proof. So that's around like 60, 70% ultimately at the end of the day. So when we're talking about the TCPA, we have the similar phrase clear and specific, which is different than clear and convincing. So something that's specific just has to be specified. It just has to be understood what we're talking about, right? It doesn't have to be convincing. For something to be convincing requires it to be not just clear what it's talking about, but also persuasive. So clear and specific should not be confused with clear and convincing, which incidentally is something that I think every other lawyer talking about this that I've seen online has done, because they are kind of confusing unless you keep them straight in your mind. In searching for guidance on how to decide actual malice standard applies to these facts, we note the Supreme Court in St. Amidant held that evidence that a story has been fabricated might be evidence. If the story is completely made up, it might be false. I guess you could luck yourself into a true story, but This Texas Supreme Court relied on the following language, which described actual malice standard under Texas law. The defendant in defamation action brought by a public official cannot, however, automatically ensure a favorable verdict by testifying that he published with belief the statements were true. Automatically ensure. A mere belief is not enough if you acted negligently or recklessly, right? The finder of fact must determine whether the publication was indeed made in good faith. Did you close your eyes? Did you close your ears? Professions of good faith will be unlikely to prove persuasive, for example, when a story is fabricated, is a product of imagination. Yeah, it's a little bit hard to square those two things. I believed it to be true, and I acted in good faith, even though I made everything up. Those two statements do seem kind of hard to square with each other. I acted in good faith. I had a good faith belief it was true, even though I acknowledge I invented the whole thing. Seems a little bit difficult to hold those propositions at the same time. Or is based wholly on unverified anonymous telephone call. Yeah, unless the anonymous call gives you enough details. So this would go to the level at which the anonymous call provides details or not that makes them convincing. So you could look at that. Nor would be likely to prevail when publishers' allegations are so inherently improbable that only a reckless man would put them in circulation. If it seems very unlikely, maybe you should look into it a little bit. Likewise, recklessness may be found where there's obvious reasons to doubt the veracity of the informant or accuracy. Yeah, so those would be clues that maybe something is going afoot here. Though they're not a precise analogy, cases dealing with allegations of sexual assault, which remember used to be per se defamation, which apparently we're not doing anymore for some reason, provide some guidance on how to apply the actual standard malice in cases where private person stories were told that were dramatically opposite. For example, a federal district court in Kansas dealt with defamation claim based on a Facebook post accusing the plaintiff of sexual assault that occurred in a private setting, which is very similar to the Vic Mignogna allegation, at least in part. The plaintiff denied that sexual assault had occurred. Chastain explained how the facts the stories were at odds prevent dismissal of the case for failure to provide evidence of actual malice. Defendants state the plaintiff cannot provide evidence of defendant knew the allegations regarding the sexual assault or attempted assault were false and therefore cannot show actual malice. The court finds this unpersuasive. In the Facebook post, defendant stated that plaintiff had abused her or attempted to abuse her, going into great detail about the narrative. Such recounting from the defendant's perspective necessarily requires a lucid memory of the event as experienced. Of course, in the event of forming a basis of defendant's accusation never occurred, as the court is required to assert, such a first-person narrative would require a defendant knew that the events were false because she never experienced them. A defendant knew the events were false and nonetheless wrote details describing them. It's axiomatic she wrote her narrative with actual malice or actual knowledge. So if she's lying, that would do it. If Chastain also explained what, of course, we assume them to be true at this stage, right? At the preliminary stage, we assume them to be true. So at the preliminary stage, unless we can somehow prove that they're false, like through an alibi or something, right? So short of that, but we'll assume they're true. But if ultimately they're false, then yeah, that would do it. In Ratner, another federal court dealt with a similar fact pattern as that in Chastain. Ratner highlighted that she's operating as we are, outside the usual ambient journalistic setting. I'm not sure where you're getting this idea from that actual malice is inherently a journalistic setting. I don't get it. I mean, New York Times versus Sullivan did concern the New York Times, which is obviously a journalistic paper. But I'm not quite sure why you think it's limited to that context in some way. Ratner explained this case is not defamation against publisher or journalists investigating events. Rather, the complaint here alleges defendant Kohler knew her Facebook post was false when she published it because the events never took place. And they're wholly fabricated. Sounds like actual malice to me. I'm not sure why the media is relevant to this one way or another. Ratner held the dispute regarding whether an event had occurred with evidence of fabrication relied on California's authority of similar import to the language we've quoted. From the Bentley opinion, where California courts held that actual malice may be inferred if plaintiff demonstrates defamatory statement has no basis in fact, was fabricated, or was the product of her imagination. Like, duh, right? Duh. Here, Watkins denied that she had stalked Miller on Facebook and made fake profiles so she could friend him. Later in her declaration, Watkins stated, "I never create fake motive profiles for any reason. I do not share posts." Watkins denies she's taken everything out of her daughter's room and forced her to sleep on the floor as punishment. Watkins attached a photo declaration showing her defendant's room was furnished and asserted the photos showed the state of the room at the time when Miller had accused them. Watkins' declaration stated Miller knew the claims she made were false and known to be false. I mean, yeah, that would do it. That would do it as a rebuttal. The problem is the clear and specific element of it, right? This is where Vic Mignogna fell down. This is where Ty Beard fell down, right? So we have a contest as to the truth, but we have a problem on the proof of clear and specific evidence because Ty Beard screwed it up, in my humble opinion. Watkins also presented evidence of an injurious motive on Miller's part. As we've noted, the other parents who filed declarations stated that Miller had said that she was not going after Watkins and she used Facebook to retaliate. Further, Miller apparently made efforts to have Watkins removed from teaching the class and from the school, but she tried to retrench that claim by claiming she'd done so only after the school had lied about what her daughter said. This is circumstantial evidence that Miller herself apparently feared how her statements and actions might throw motive into question. To determine if there's prima facie proof of actual motive, we look into circumstantial evidence of whether, from a subjective viewpoint, the defendant, in fact, entertains serious doubts as to the truth of publication or a high degree of awareness of the probable falsity of published information. Duh, right? Here, one private party claims the acts occurred, the other party denies it, which is enough for a factual dispute. In other words, each one claims they're lying. So there's a factual dispute. Okay, great. Further, though, the injurious motive is not determined of actual malice is a factor that may be considered. If I was trying to injure you, it makes it more likely, one would imagine. Here, Miller's words and actions create an inference of injury. Miller's ire that Watkins had made statements about her, although her statements were made to a limited office of Watkins as husband, is obvious. Her words that she was going after Watkins and her social media posts were methods of retaliation. The evidence raises an inference of injurious motive, and in combination with others is relevant to Miller's subjective belief regarding whether her statements were true. The record supports an inference to a prima facie standard of actual malice. How are we doing on this? We're 43 pages into how many pages? I think it's 50 something. So we still have a little while to go. We've been at this for 2 hours. Because statements by Miller we conclude are defamatory constitute defamation per se, it's presumed that Watkins has suffered general damages. If we could not rely on this presumption, wait, I'm confused. Is defamation per se still a thing or not? Because the statements by Miller we conclude are defamation constitute defamation per se, it's presumed that Watkins has suffered general damages. Even if we could not rely, present prima facie proof that she's experienced anguish. As we noted above, though, terms have fallen out of favor. What? Are they still a thing or not? I'm so confused right now as to the state of the law. The Court of Appeals is not helping me understand the law right now. Is defamation per se still a thing in Texas or not? Even if we could not rely on the presumption, Watkins present prima facie proof she expended mental anguish. As we noted above, though, the terms have fallen out of favor. Terms defamation per se and per quod remain viable in determining whether a statement provides a presumption of damages. What? Hold on. Okay. The Texas Supreme Court established new categories to address these questions and abandoned other than for the purposes of presuming general damages. The long-used category of per se and per quod. I don't even understand what that means. The only difference between per se and per quod was the presumption of general damages. That's like the only difference. You had to allege damages. You always have to allege damages. But in per se, you didn't. They were assumed. So the Texas Supreme Court abandoned these terms except for the only purpose that which they were relevant for in the first place. What the hell is the Court of Appeals talking about? Or what the hell is the Texas Supreme Court talking about, as the case may be? What do you mean the Texas Supreme Court abandoned other than for the purposes of presuming general damages? As opposed to what? What other purposes are there for per se or per quod other than the assumption of general damages? Literally the only difference between per se and per quod is the assumption of damage. What do you mean the Texas Supreme Court abandoned other than for the purpose of presuming damage? The categories of per se, per quod. What the hell are you talking about? Either the Texas Supreme Court isn't making sense, or more likely, the Court of Appeals isn't making sense, quoting the Texas Supreme Court. That doesn't make any sense. I am so confused. All right, anyways, back to page 47. Was it 37? What page was I on? Okay, I was on page 43. The distinction between per se and per quod is false. Historically, defamation per se has involved statements that are so obviously harmful that a jury may presume damages. Defamation per quod is defamation that is not per se. In other words, you have to prove damages. So the Texas Supreme Court has abandoned per se, per quod, except for the only reason that they were relevant in the first place. What? Accusing someone of a crime, having a foul or loathsome disease, or engaging in sexual misconduct are examples of defamation per se. What? The existence of defamation per se presumes general damages. That's defamation per se. As the Supreme Court has explained, actual or compensatory damages are intended to compensate a plaintiff for injury they've incurred and include general damages, such as non-economic damages, loss of reputation, or mental anguish, and special damages, which are economic damages for loss of income. Historically, defamation per se claims allow the jury to presume the existence of these damages without proof. Yeah, that's kind of what they do. But the First Amendment requires competent evidence to support an award of actual or compensatory damages when the speech is public or a level of false than actually malice. Thus, this Constitution only allows juries to presume the existence of general damages in defamation per se cases where the speech is not public, which is public concern, or plaintiff proves actual malice. Okay. Also, prima facie proof of viable defamation per se claim frees the party responding to TCPA motion dismissed from having to present clear and specific evidence of damages. Okay, that's neat. I didn't know that. Pleading and proof of particular damage is not required to prevail in the claim of defamation per se unless actual damage is a non-essential element. Okay, that I did know. Yeah, I just misread it, right? So yeah, you wouldn't have to clearly and specifically claim general damages in defamation per se because it's not a required element in the first place. That's what per se is. What? Here, Miller actually accused Watkins of two potential crimes, child abuse and online impersonation. Further, Mueller's allegations that Watkins is evil and vindictive mother, as demonstrated in part by her abusive actions towards her own daughter, would strike at Watkins' ability to be a substitute teacher and obviously used by Miller for that purpose. Thus, we consider these statements to be defamatory per se. Further, to the extent these statements have a public component, we also have already concluded that Watkins presents public facial proof the statements were made with actual malice. Thus, we conclude the presumption of general damages frees Watkins from having to present prima facie proof of damages. Okay, so, okay, so I have no clue at this point what the Texas Supreme Court did or did not do, because the Court of Appeals is saying this is defamation per se. which it would be at common law. So that must mean defamation per se is still a thing. So I have no clue at this point what the Supreme Court was talking about. Apparently, according to the Court of Appeals, when they said, oh, we're kind of getting rid of these terms. In what sense? I don't know. $40-something, which I don't recognize this symbol. I think it's is it Indian ruples or something like that? 40-something. What ain't you stretching with this, Nikki, Kurt? I don't understand the comment, but I appreciate this, okay? I appreciate the money. Thank you. It's very nice. Alternatively, if wrong in applying the presumption of general damages, then we conclude that Watkins presents prima facie case of mental anguish. Generally, mental anguish is only compensatable if it causes substantial disruption. In essence, proof of compensatable mental anguish looks to the degree of emotion it produces. Yeah, that makes sense. How much compensation you need would directly relate to how anguished you are. I mean, yeah. Rupees. Thank you very much. In sufficient review, we must distinguish between shades and degree of emotions as between disappointment and severe disappointment, between embarrassment and wounded pride, and between anger and indignation. How much you've been hurt would go to how much damage you have. But generally, conclusory descriptions of how it affected a person are insufficient by which to base it. Yeah, you have to actually show those things, not just merely describe those things, yeah. I believe the question is why you're not currently presenting the stream in cooperation with Nick. Well, Nick already did his own analysis on this case. He did it a week ago, and I'm doing my analysis on this case. And why Nick didn't invite me, I couldn't say to. And why I didn't invite him was because I woke up this morning and felt like streaming. So, I don't think Nick wakes up for a couple hours. Watkins' declaration contains more than conclusory and superficial claims of anguish, as shown by the following. I love teaching art. This past school year was my second year to do so, my first year in charge of Meet the Masters program at Brockett Elementary. Before all of Carlisle Miller's actions that part of this lawsuit, I would dress up like the artist or from the time period to engage my students. After Miller did what she did, as continued to do, I did not dress up as often. When I did get dressed up, I get anxious every time before I knew Miss Miller was going to be at the school to help with the children's classes. She never helped as a parent volunteer in the art room for all those years I've taught the program. I knew she was saying false things about me, and her presence in the classroom was frightening and intimidating and extremely upsetting. It's more than mere conclusion. It's providing some evidence along the lines, right? No. A few days after Miller made her Facebook post that's attached to Kelly Casey's declaration, Miller was up in school decorating for the event. I would normally stay to help with decorating as I've done, but I did not feel comfortable. I'd say hello to my friends and left. The stress of knowing that she could email the school or I'd have to talk with her principal about demands was causing me anxious and my stomach would turn. I felt uneasy about going to school for any reason, fear that she might be there or show up. I saw my doctor discuss options for stress and anxiety. I started counseling. I discussed the situation many times during my session. So, that's more than mere conclusion. When Miller was in the classroom, I do my best to teach and focus, but her hostile presence would be distracting. I broke it down in school a few times when just could not hold in the stress. I'll skip the rest of this because I think we got the point. Watkins' relatively detailed statements of the anguish she suffered established prima facie clues. Yeah, it's not mere conclusion. It's more descriptive than that. In reaching the conclusion, we rely on opinions from Texas Supreme Court reviewing mental anguish awards on appeal and compare these holdings. Following are examples of various statements that the Supreme Court has found sufficient in prior cases. The plaintiff testified that he lost time with friends and family, spent time worrying and distressed about the impact the statements had on with the community. Blah, 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 whatever. It doesn't matter. We know it's there. By comparing the statements to the quoted descriptions, we conclude she presented clear and specific evidence. Her routines were disruptive. She experienced physical symptoms, experienced stress, altered her plans. It's more than enough. Yeah, I agree. And then we talk about Miller's brief is so deficient, they've waived any argument that they failed to present clear and convincing evidence. So Miller screwed up on the appeal and waived the argument that they failed to provide clear and specific. So we'll just skip that because that's going more to Miller screwing up than Watkins' claim. So we'll just kind of skip that because it doesn't matter right now. On the record before us, Miller has not established the case should be dismissed for his failure to comply. Yeah, we kind of reached that conclusion already. Blah, 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 blah. We reject Miller's argument that Watkins' request for injunctive relief should be reviewed as a discrete legal action subject to dismissal. Okay. In the second issue, Miller attacks what she clarifies as Watkins' third cause of action, request for injunctive relief. That's not a cause of action. Are you an idiot? A request for an injunction is not a cause of action. That's stupid. Miller offers a litany of reasons why requests for injunctive relief is invalid and should have been dismissed. They include the request is an attempt to change the parenting arrangements or by the decree of divorce between Watkins and her ex-husband. An injunction would impair the ability to exercise a number of her constitutional rights. That doesn't make it a cause of action. The fact the trial court did not grant any injunctive relief and stated it would not impose a prior restraint. More fundamentally, the attack is misdirected. Request for injunctive relief is not a separate legal action to which the TCPA motion to dismiss may be directed. Of course it's not. That's a stupid argument. A cause of action is a basis for me to sue. A cause of action is you done wrong. What have you done wrong? You defamed me. You hit me. You trespassed on my property. Whatever. You've committed these criminal acts. What did you do wrong? That is a cause of action. Here's what I want from the court is not a cause of action. It's nothing about what you did wrong. It's here's what I want the court to do about it. You can't, if it were a cause of action, that could mean that you could literally plead as a cause of action without anything more, just a request for injunction. It doesn't even make sense. That's stupid. Who argued this? A TCPA motion to direct is directed to a legal action. Right. Blah, 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 whatever. Okay, great. That's the end of that case. Dismissed. All right, so we got to the end of the thing. Yeah, that's done. All right, so what did we learn about TCPA? Well, we learned a little bit more about what clear and specific looks like, I suppose. We learned what it means to be clear and specific. It just elevates notice pleading to a higher standard. And so that's what we learned. So how does that read on the Vic Mignogna case? Well, it doesn't really read on it at all. The operative question is whether the second amended petition is operative or not in the Vic Mignogna case. That's the operative question in the Vic Mignogna case, it seems to me. Is the second amended operative? If it is, then I think that Vic has probably presented enough evidence to go forward on at least some of his claims and should be reversed. If it's not, then Vic's done. So it boils down to whether the second amended petition is operative or not. So the second amended was offered like something around 5 days, 7 days, 10 days, something in that time frame. I think it was 7. Often, or 10, something like that. It was offered shortly before the TCPA hearing. And it appears the court denied entry of it. Although the court was a little bit vague about it. And so I think there's a 90, I'm still basically where I was before. I think there's about a 90% chance. There's a 90% chance the Court of Appeals will affirm. There's about an 8% chance they'll reverse and say the record is unclear, fix it, which is kind of a technical win, which won't really matter. And there's a 2% chance the Court of Appeals will say the court abused its discretion by not entering the second amended. So if that happens, I'll be surprised. So, yay. So, yeah. That's where I think we are in the Vic Mignogna case. And I believe the Court of Appeals comes down with their decisions on Thursdays. So we should get a decision pretty much any time now. The court, it was submitted like 5 months ago or something. And the Court of Appeals normally is supposed to decide within 6 in Texas. So I think that 6-month date is coming up real soon. This was November, right? November, December, January, February, March. So yeah, I think we're in like month 5. So yeah, the decision is expected to come down pretty soon. And I think it comes down on Thursday. So if it comes down on a Thursday, we'll definitely cover it. And we'll figure out whether or not I'm right or not. And if the Court of Appeals reverses in a substantive way, I will be massively surprised. And I'll have to eat crow. But that's okay. We can be wrong sometimes, right? And then the entire chat, then the Vic Mignogna people will go endlessly crazy on me and mock me and be like how I knew nothing wrong because I got it massively wrong. You know, what can you do? What can you do? Maybe I shouldn't have given the odds that high. Maybe I should have reduced them down, but I'm not going to do it now. Oh, well. I hope you enjoyed this rather spontaneous morning stream. I wanted to stream with you early in the morning. I hope you enjoyed it. I enjoyed it. If you haven't done already, for the 97 of you who are currently watching, could you make sure to like the video on your way out? It would be appreciated. If you're not subscribed already, why not? Please subscribe. And did you know for 99 cents a month, you too can join the channel and help the channel grow? It's true. Please click the links that Streamlabs has been telling you about or hit the join button. Either way, my friends, I'll see you later. Until next time, I'm out. Peace and goodbye.